Welcome back to Court TV Live. I'm Michael Ayala. Court TV is tracking a new case out of Massachusetts. It's the murder between brothers case of Jaylen Lambert. Now, Lambert is charged with second-degree murder for allegedly shooting his brother, 20-year-old Jaleale Simmons, to death inside their home back in March. Now, Lambert was 17 at the time, and according to prosecutors, it all stemmed from an argument over money. And now the state is fighting to keep Lambert in jail without bond, calling him a danger to the community. Now, both sides took their arguments before the judge today, and we're going to bring you that hearing now. Let's get inside the courtroom now for the state's argument.
Your Honor, the Commonwealth would argue that based on its submissions, that the Commonwealth has shown by clear and convincing evidence that the defendant is dangerous and that there are no conditions released that would ensure the safety of the public. The evidence the Commonwealth would suggest establishes that on March 15th of 2025, that this defendant was present at his residence, which was the third-floor apartment, 983 Broadman Street. He resided there with his older brother, who was 20 years old, Jaleale Simmons, as well as his mother, Nikea King. During that early afternoon, around 12 o'clock, there was an altercation that took place between the defendant and his brother. The backdrop of that altercation involved some money. Ms. King had recently provided money to the defendant, who had just turned 17 for his birthday. Ms. King needed to request some money back from the defendant. The basis for her needing to get money back was based on the older brother had spent some money that she thought would be used for groceries, so she needed to get money back from this defendant. That caused the two brothers to start verbally arguing regarding the money that had needed to be returned to Ms. King. During that verbal argument, both boys were disparaging each other back and forth. The defendant was calling his older brother a bum. That verbal altercation became physical. During the physical argument, the older brother, Mr. Simmons, did grab the defendant around the neck and start choking him. Ms. King testified before the grand jury that that took place for about 10 to 15 seconds. During that, it appeared that the defendant appeared to be gasping for air. He was able to remove himself from that situation. The argument then continued. Ms. King took up her cell phone and attempted to record what was going on between the two boys and inadvertently took a photograph. That was one of the exhibits that the Commonwealth admitted, so the court can get an idea of the size of the two boys that were involved. The two boys in the photograph, which is exhibit number 14, are essentially head-to-head, facing each other. They don't appear to be at blows at that point of time in the photograph, but I would suggest that you can tell that it appears to be a tense situation. Following her taking that photograph, the boys start to become more physical. She describes that they are now throwing punches at each other, at which point she attempts to call 911. There is a 911 call that goes through at 12:23 p.m. She indicated before the grand jury that Mr. Simmons hung that phone call up by, she's holding the phone out in her palm. Mr. Simmons walked over to the phone and hang up. As a result of that happening, the fight continues. She attempts to call 911 again. She's unable to dial the number, and she describes frantic. She's frantic at that point. She misdials the number. That's reflected in a phone extraction of her phone. There's a 911-22 call or attempted call that does not go through. There's a further 911 call that goes through at 12:27 after the culmination of what happens that's reflected in the phone records, which Ms. King says she witnesses as follows. After she attempts to call 911 and Mr. Simmons hangs up the 911 call, the boys are again going at it. Mr. Simmons puts the defendant in a headlock again, is choking him. She estimates that this was for less time than the initial time that she had already described, that the Commonwealth had described during the initial encounter. During that, she's able to break it up, and she pushes Mr. Simmons into his bedroom, into the threshold of his bedroom. while she's in the common area or the kitchen of their small 3-bedroom apartment, and she identifies the defendant as being behind her. She indicates in her grand jury testimony that Mr. Simmons pushes her to the ground, at which point the defendant helps her up, and then she removes herself from the situation shortly following that interaction. She goes into the kitchen, she sits at a kitchen table, leaves the boys. At that point, she's removed herself. She's not able to effectively stop what's going on. It's at that time that she sees that there is a gun in this defendant's hand with a large magazine. She indicates that the two boys had been trying to go at each other while she was in between the two of them, that they're now jawing at each other. Ultimately, both boys say at the same time, "What you going to do about it?" According to Ms. King, at which point in time, Mr. Simmons punches the defendant, and the defendant immediately fires a single shot into his chest. She calls 911. Police arrive very quickly, within 2 to 3 minutes. When officers arrive on scene, this defendant answers the door. He says, it was me. Officers order him to the ground. He complies. He indicates that his brother's in the other room. He says that there's a gun on the couch. Officers go in and they attempt to perform life-saving efforts on Mr. Simmons. Unfortunately, when police initially encounter him, he's not showing, he's fairly unresponsive. Police are doing what they can. He's ultimately transported to the hospital where he's pronounced deceased at 1:05 p.m. During that time, the defendant is on body camera. He's very distraught, indicating that it wasn't supposed to happen the way that it happened, and expressing regret for what had happened. When he was taken to the police station, he had made some spontaneous statements that he had killed his brother in front of a detective. The detective told him not to make any more statements, that an interested adult would be coming, and that he should consult with an adult before he says anything. Police execute a search warrant. During the execution of the search warrant, they find the firearm, they find the magazine. That's been admitted as exhibit number 12. You can see it's a very long magazine. It was capable of carrying well in excess of 10 rounds. I believe it was 26 rounds that it was capable of carrying. During the grand jury presentation, Ms. King had also indicated that she had never seen that firearm before. She had, during her initial interview, attributed it as being the defendant's gun. In grand jury, she clarified that she said that because it was in his hand, but she had never seen it before, and she doesn't know whose gun it was. Neither boy possessed a license to carry, but her testimony is that she saw this defendant in possession of it during the altercation, and that he fired the shot, killing his brother, following their argument over essentially money. I would suggest to the court that based on the nature and circumstances of this incident, that this is obviously an extremely serious case. It's the most serious charge that can come before the court, other than the fact that it's a second degree instead of first degree. He did kill his brother. That's what he's under indictment for. There are very serious penalties for that. It occurred while he was at his residence under the care of his mother. I would suggest that based on the situation, the circumstances, the fact that mom was unaware that there's a gun in the house as well, that not only is this defendant dangerous, but that there are no conditions of release that would assure the safety of the public based on everything that's before the court. And I would ask that Your Honor find that the Commonwealth's met its burden and hold the defendant without bail prior to trial.
All right, thank you, Mr. Lopez-Discapiccio.
Thank you, Your Honor. So it's our position that Mr.
All right, so those were the prosecution's arguments as to why he should be kept without bond. We're going to pause it right there. Now, when we come back, the defense attorney is going to present the defense's argument, and then we're going to hear from the judge as well as to his decision if he makes one. Let's keep it here on your front row seat to justice. A man found shot in the face after his wife reportedly said that she wanted him dead.
Could her own words end up sealing her fate?
That smoking gun could not stay hidden forever.
The Widow's Words murder trial. Live coverage today on Court TV.
Tonight on Closing Arguments, a case of alleged affairs and protein shakes laced with potassium cyanide. We're diving deeper as the poisoned shake murder trial It's underway.
Closing arguments tonight at 8, 7 Central, only on Court TV.
Before we get you back to court, here are a few other trials that Court TV is currently tracking. In Massachusetts, Karen Reed has filed a motion to dismiss the wrongful death suit filed by John O'Keefe's family. Now, Reed was acquitted last month of second-degree murder and manslaughter in the 2022 death of O'Keefe, her Boston police officer boyfriend at the time. O'Keefe's family filed the civil lawsuit against Reed last summer after her first trial ended in a mistrial. And in Idaho, officials have ended the search for Travis Decker in an Idaho forest after finding the look-alike hiker who had been reported to authorities by a family on July 5th. Decker, who is accused of killing his 3 young daughters, hasn't been seen or heard from since the girls were found dead on June 2nd at a campground in Washington. And in Maine, police are investigating the death of a paddleboarder as a homicide and asking the public for help finding her killer. The body of 48-year-old Sunshine Stewart was found last Thursday on a pond near a rural playground. All right, let's head back to Massachusetts now for more in the murder between brothers case of Jaylen Lambert. He's accused of shooting and killing his older brother after they got into an argument over money. Now, both sides are arguing over a motion for bond. The state says it should be denied because Lambert is and remains a danger to the community. All right, let's head back to court now where the defense attorney is presenting her argument to the judge.
Lambert is not a danger to the community, Judge. This was started as a family fight. He has virtually no record. Just so the court's aware, this issue starts because Jaleale, who's the older brother, who has about 50 pounds and some inches on my client, and my client had been in prior altercations where Jaleale had beaten my client to the point where his mother had to call 911. There's at least one criminal charge against Jaleale as a result of holding my client against a radiator in an altercation that they had. And this particular day, Judge, the family was out of food. Jaleale was a representative payee for the mother. He was in control of all the money. The mother had asked him for the money. He refused to give it to her. She then went to my client and said, the money that I gave you for his birthday, because this was 3 days after his 17th birthday, Judge. So she asked my client to go and ask Jaleale for some money back so that they could buy food. That's what the whole fight started on. This was not something that they were, it was hemming and hawing for weeks. This is not the first time that Jaleale had refused to give the family money. He was in complete control of all of the money of the family because the mother is disabled. She gets a Social Security disability check, and Jaleale was the representative payee. So he was in control of everything. On this particular day, Judge, there's no doubt in my mind, after having heard everything that the prosecutor said and investigated this case, that on at least 2 occasions during this altercation, Jaleale had his hands around my client's neck, squeezing the life out of him. And then what caused this issue to happen, Judge, is complete self-defense and defense of others. I don't know who introduced the gun. The Commonwealth doesn't know who introduced the gun. All I know is the gun doesn't get introduced until after the mother gets pushed to the ground. My client has to help his mother, his disabled mother, up. And then he's attacked again by Jaleale. And at that point, Judge, according to the Commonwealth, there's a gun and there's a single shot. This isn't a situation where this client runs away. If you look at the body cam footage, he is sobbing, literally sobbing when the police get there. This was not something that he wanted to have happen. This is not something that was in any way, in my mind, any malice at all. I can't believe they indicted him on second. I really just, I can't believe it based on what they knew. But the grand jury did what they did, and we're stuck with that. But this is not an individual who's a danger to the community, Judge. He's an individual who literally fended for himself for a number of years during his mother's sickness. He dealt with his brother's abuse for years. And at least, I think the Commonwealth put the issue before the judge. If it doesn't, I can certainly get the court copies of the district court case where the brother had held, Jaleale had held my client against a radiator, and they had taken photographs of the burns on my client's back as a result of what his brother did to him. So this is a situation, Judge, where I don't think that the Commonwealth meets their burden. He is not a danger to anybody, Judge. His family, unfortunately, can only come up with $6,200, which I know is not a lot of money, Judge. Like I said, the mother is disabled. There's an aunt in the picture who might be able to come up with a little bit more money, but that's what they have at this point. The father is in the picture. He was actually here this morning, Judge. He had to leave because he had to be at work by 11:30. So he was here this morning. I did have a conversation with him. Jaylen knows his dad was here, but had to leave to go to work. So at this point, Judge, he is being held as courtesy by DYS. He is custody of the Bristol County Sheriff's Department. He's being held in a DYS facility. And he does have access to education and counseling right now, Judge. But my suggestion would be that he is not a danger to the community, that he is not a risk of flight. He stayed, he talked to the police according to the Commonwealth, and made, according to the Commonwealth, some confessions or some admissions on video. But Judge, this is not a situation where I think anyone has to worry about him being a danger to the community. This is if anything, a one-off, and it's his brother, Judge. It was tough enough for him not to be able to go to his brother's funeral, not to be able to comfort his mother during her time of grieving, but now he's completely separated from his mother, who's still in the grieving process because the brother is dead, but also now finds himself fighting for his life, Judge. And I'm just saying the Commonwealth, under these circumstances, very specific factual circumstances, don't meet the burden of proving that he is a danger to the community and that he needs to be held under Section 58A.
Tell me if there were any types of conditions, where would he stay?
He would stay with his mom, where he was staying prior to this. There's no issue with anyone else, Judge, because the brother is deceased. There is an aunt that lives upstairs that would also be able to assist in this case. There are various friends and family members who are in the courtroom here supporting him. They've been here every single court appearance that we've had. Everybody is rooting for him to be able to get out and be able to defend himself, Judge. The problem is the family can only come up with $6,200.
Okay. All right. I'll take the matter under advisement.
Thank you.
Thank you.
All right, so you heard the judge there. No decision today. He'll take it under advisement. He'll give his decision at a later date. I want to bring in my guest, joining me now to discuss his Nashville trial attorney, Michael Jaffer. Michael, great to see you. Thank you so much, as always, for joining me here on the program. And this is a tough one, Mike. When you look at it at its heart, it's a domestic violence case. Right? It's not one that we're used to seeing, but it's a domestic violence case. Two brothers. One of the brothers seems to have had some problems in the past. This particular brother, who is standing trial or will stand trial, doesn't seem to have a background. We hear this a lot, Mike. Oh, he was a good kid. Seems like this might have been a good kid. What do you think the judge, what might he be looking at in this case, and what might he do?
This is a Greek tragedy of epic proportions. So here's my take on this case, right? So murder is a capital offense in Massachusetts. So it's technically punishable by life in prison without parole. So this gives this judge broad authority to deny the bail outright, and he would be standing on good ground if he does that. However, courts can set bail in murder cases even if the evidence of guilt is not strong or the facts suggest some sort of a justification such as self-defense. This case qualifies. I like what the defense attorney did, which is she went deep into the economics of the family so that the judge could have a textured fact pattern to decide on. It's not just, hey, I'm going to set a very low bail, $20,000. Well, $20,000 for this family, judge, you might as well make it at $10 billion. That's essentially what she was telling the judge. Either make the bail $2,000 or make it $10 million. Those are the two options that you have, and I think that you should set bail. That's what the defense attorney was saying. So what do I think the judge is going to do? This is a tough one. This is a coin flip for me. This is like a coin flippy type of situation. I think he might let the kid out on bail after maybe 30 days after a cooling off period. I think that's what he would do. I don't think he's going to let him out in the next couple of weeks. I don't think he'll let him out at all, but if he is going to let him out, he's not going to let him out for at least another 30, maybe 60 days. He's going to let him stew a little bit to kind of calm down the situation, because it's on the judge's hands if he lets him out and something else happens. Some other family member hurts him, kills him, or he defends himself from another family member. This is a tough one.
Yeah, and you know, there are a lot of factors in his favor. He's got ties to the community. Defense attorney made that clear. Folks in the courtroom supporting him. Even his dad was around. You know, part of the problem, though, he doesn't have a lot of criminal history. I don't believe he's a risk of flight. Not a lot of money in the family. The question is whether he's a danger to the public. And there's this one point that was brought up by the prosecutors. Now, the defense attorney said if he got out, he'd likely stay with his mom. And one of the things pointed to by the prosecutors that I thought was a really good point in terms of his dangers to the community is Mom said she didn't know that he had the gun. So if he goes back to his mother and she doesn't have that kind of control over him to know when he has a gun, a large caliber gun in the house, how do we know that he's not going to be a danger, Mike? That's part of the problem.
That's an excellent point. The defense attorney knew that that would be a problem, so that's why in her illustration she said, we don't know where the gun came from. Also, the Commonwealth doesn't know where the gun came from. So she was telling the judge, essentially, she's giving him like an arrow in his quiver if he wants to let him out, to say, maybe my client never even brought in the gun. That's what she was intimating. And you know what? Now that you bring it up, Michael, I'm glad you brought it up. There might be a redone hearing by the judge where the judge might want to ask for some more evidence as, do we know where this gun came from? Because the defense attorney said even the Commonwealth doesn't know where the gun came from. So hypothetically speaking, let's say he did not bring the gun to the house, but he knew the gun was there. Let's say his brother brought the gun to the house. That would change the judge's decision. So I'm glad you brought that up. Hadn't thought about it till you just brought it up. So that is the biggest point, because if he did bring the gun to the house, he's not getting bail. I don't care. Even if he wins the lottery tomorrow, he's in jail until the trial is over if he brought the gun.
Yeah, I would agree. And the mom, in her initial statement to police, says that it's his gun. See, he got his gun. Later on, she changes it and says, oh, I just meant he had it in his hand. I don't know where he got it. I wasn't aware there was a gun in the house. And as I think about this case, and if it goes to trial, Mike, it's really going to be her testimony that's going to either put her son away or keep him out. So she's in a bad spot because she's the only one who witnessed the whole thing.
Michael, I did not know that until you just said it. Because of that, I think this mom is going to be, she's going to be hell-bent on getting this kid acquitted. She's going to testify. She's going to say, I was a witness. My son, the surviving son, was not the aggressor. So if she said that to the police and she flipped her story, we don't know whether or not she's lying or not. But my hunch is you changed your story because you were lawyered up and then you told them, hey, I don't know, I was wrong. If that's the case, if my hunch is correct, she's going to testify in favor. She's going to intercede in favor of the young son. What a Greek tragedy. You lost terrible. One son. That's terrible.
It's terrible. And again,
terrible.
He is claiming self-defense, Mike. So, her testimony is going to be key. And I wonder if he'll testify as well.